Morning, everyone, and thank you for joining us for this morning's webinar on understanding Social Security programs and services. We are very excited to have Kim Stevens joining us this morning to give us an overview of these programs and to let us know what's new or what could be happening in 2025. So at this point, I would like to introduce Kim Stevens from she's a public affairs specialist with the Social Security Administration. So good morning, Kim.
Good morning. Happy Monday, everyone. Thank you for having me today. As Patty mentioned, first of all, thank you again for the invitation, and hopefully you find this presentation helpful. Hopefully you'll learn some things maybe you didn't know before, and maybe reinforce some concepts that you already knew. So I did want to put a face with the name here for you, although it is rather dark in here. It's my laptop. I'm using an older laptop for this presentation, but it does perform better when I turn the camera off. So I am going to do that now. All right, so let's just jump right into our topic this morning. We are going to, first of all, I'm going to give you a general overview of our Social Security programs. Just like everything, subject to change, right? So Social Security policies and our services may change as well. So just to make sure you get the most up-to-date information, please visit our website, ssa.gov. So we're just going to start with the facts here, and forgive me for the transitioning here. I'm just going to click them all, get them all up on the screen for you. I'm hoping that's the last slide that I do that with. I keep meaning to disable that, and I have not done that yet. So first thing we're going to talk about is the basic standard Social Security benefits, or what we consider Title II. This is for individuals who are working and paying into Social Security through a payroll tax deduction. So that money is actually set aside when you work and pay Social Security taxes. It is set aside for specific types of benefits. The money goes into what we refer to as a Social Security trust fund. Those benefits payable can go to an individual who meets the retirement benefits, people who are disabled, survivors of workers who have died and paid into Social Security. That can be spouses, divorced spouses, and children. And then other dependents, if the wage earner, the person that paid into Social Security, is living, could be in the form of auxiliary benefits paid to spouses, divorced spouses, and children as well. So other factors under the Social Security benefits, or Title II, is the amount a qualified beneficiary can receive is going to be determined on the wage earner's work history. So everybody's amount is different because our wage and work history is different. Amount is not dependent upon income and resources, so we normally will not ask factors of what other forms of income do you have coming in, what are your resources, things of that nature. Your retirement and disability amounts are there based, again, on your work history, what you've already paid into the program. And all the funds for the benefits that I just mentioned come from that Social Security trust fund. So the most common one is our retirement, and you may already be aware of the details behind the retirement. I don't go into specific, minute details here during this presentation because we're kind of just doing a general overview. So we're not going to go into the nuances of each of these. I do a 2-hour presentation on retirement alone, so we won't be doing that to you today, okay? So if you don't already know, Social Security is derived from the Federal Insurance Contribution Act. You may see that on your pay stub as OASDI, which is Old Age Survivors and Disability Insurance, or it simply may say Social Security. So out of that, you're going to notice, oops, we're getting all jumpy here this morning. Out of that, you're going to notice that you're going to be contributing 7.65% of your wages towards Social Security and Medicare. Social Security, again, is that retirement, disability, and then Medicare, of course, is your federal health insurance. Now, 6.2% of your gross wages go into the Social Security pot, and 1.45% goes into the Medicare fund. Now, your employer will match that 7.65% to bring you up to a total of 15.3% of gross wages contributing towards Social Security and Medicare. Now, if you are a self-employed individual and you wish to contribute into the Social Security and Medicare programs, you would pay the full 15.3%. Okay, so how do you qualify for retirement? The basics are if an individual were to call Social Security and say, I'm ready to receive my retirement, the very first thing a Social Security representative is going to look at is do they have the number of credits they need to qualify for retirement? So a credit is based on amount. The amount for 2024 is a gross wage amount of $1,730 will give you 1 credit. You can receive a maximum of 4 credits a year. We do have the new amounts out for 2025. So a credit for next year will be $1,810 in earnings, and that will give you 1 credit. You can earn those credits anytime throughout the year. They used to be called quarters of coverage. Some people still refer to them as quarters of coverage, but they can be earned anytime. Back in the day, it used to be you could only earn a credit or a quarter of coverage per quarter of the year. So it had to be earned in the quarter. They did away with that. If you gross $6,920 in 2024, you have your 4 credits. Now you need 40 to be what we would consider insured for Social Security retirement benefits. So that's roughly for most of us a 10-year work history. The earliest anyone can file for Social Security retirement is the age of 62. Now, once we get those credits, how do we determine someone's benefit amount? So that we're going to look at your earnings. We've got your 40 credits. And once you get that, you're good to go on that. We don't need to worry about that anymore when it comes to retirement. Now what we're going to look at is specifically your earnings. And we take every year that you worked, we bring it up to today's value. So what you made in 2002 is going to be what that wage would be equivalent to in 2025. We call that indexing. Once we do that with all your earnings, we take your top 35 years. I highlight it there because a lot of people think I misspeak and they think it's 3 years, they think it's your top 5 years, but it is indeed your top 35 years of work history that we look at when we're determining your benefit amount. We take that top 35 and we find an average. So that average becomes something called our average index monthly earnings. Once we have that number, we put it in this 3-tiered formula. Now, when I do the retirement specific seminar, I'll break that down into examples. You can see the formula, but for today, just letting you know, we take your top 35 years of averaged index earnings, find that average, and then we put it into a 3-tiered formula to determine someone's Social Security retirement benefit amount at full retirement age. Now, a common question is, well, what if I don't have 35 years? Because you don't need 35 years to receive Social Security retirement, but it does determine the amount that you'll receive. So as we know, if we put a bunch of zeros in an average, it's going to pull that number down. The more wages we have filled into that those years, the higher your Social Security retirement benefit amount will be. Now, I mentioned prior to this, when we're doing that calculation, we're going to look at full retirement age for your benefit amount. But I also said you could receive as early as 62. So when I'm talking about full retirement age, that's always where we start. We start at the individual's earnings record. The amount calculated is what they would receive at their full retirement age. That age is determined by the year you were born. So if you were born between 43 and 54, you're going to be 66 as your full retirement age. Anybody born between 55 and 59, you can see there on the chart that it's staggered, 66 in 2 months, 4 months, and so on. Now, anybody else born 1960 or later, that full retirement age is 67. And again, you can receive this as early as 62. If you do that, you do take a reduction because you're receiving it that much sooner. So anywhere from a 25% to a 30% reduction. Now, another common question is, when do I receive my Social Security retirement? And that is based on the day you were born. So anybody born 1st through the 10th, that's going to be the 2nd Wednesday is when you'll receive your payment. 11th through the 20th, 3rd Wednesday, and 21st through the 31st, 4th Wednesday of the month. So you don't have to worry about if Monday's a holiday because you're going to get your checks on a Wednesday. Another common retirement question that we have is, well, what if I choose to continue to work? Will that affect my Social Security? And the answer is it could be. So there is something called the annual earnings test. And this is applied to an individual who has their 40 credits and they decided to receive their Social Security under their full retirement age. Remember that chart I just showed you? If they continue to work, Social Security will look at how much they're earning through their wages. And we're only going to look at wages, okay? So we don't need to look at any other form of income here. It's strictly what you're working for while you're receiving your reduced retirement Social Security payment. So the rule for 2024, if you are going to gross above $22,320 in gross wages, we will hold one for every $2 out of your Social Security payment. The 2025 number will be $23,400 for the year. If you're above that, we hold one for every $2 that we're over. Quick example of this is, let's say I go ahead, I'm 63 years old, and I go ahead and I'm receiving my Social Security retirement. I tell Social Security in 2024 that I'm going to gross $32,320. So I compare it to 2024's annual earnings limit. I'm $10,000 over. Social Security will hold one for every $2, so they will hold $5,000 out of my Social Security payment. So if, for example, my payment amount was $1,000 a month, because it is Monday and I got to keep my numbers simple, Social Security will hold one January, February, March, April, and May. So they'll hold 5 months out on me for working and being above the annual earnings test limit. Now, as you approach your full retirement year, you can make a little more. So for 2024, up to the month before you reach that full retirement age, remember that's based on that chart, you can earn $59,520. If you exceed that, Social Security will hold one for every $3. If you, the very month, in 2025, you can earn up to $62,160 for the year. So if my full retirement age is June, I need to know what I'm going to be grossing between January through May of 2024. And if I'm above that $59,520, they'll hold one for every $3. The very month you reach full retirement age, there is no limit to how much you can earn as far as the annual earnings test goes. A couple other pieces before I will answer some questions about basic retirement is another common thing is individuals will say, oh, what happens with those checks that that you held from me? So when, let's say in my example, they held 5 checks from me, remember, for 2024? Well, when I reach full retirement age, they will give me credit. So they will give me back some credit for those Social Security payments that they held from me. Okay, so my benefit amount will go up when I reach full retirement age. Okay, so keep that in mind. So it's not all a terrible thing that they, hold those checks out for you, but keep that in mind. The other thing I want to mention is that as long as you continue to work, if your wage amount for the year is replacing one of your low 35 years, your benefit amount will or could potentially increase. I should say could, because it all depends on the numbers. But it is constantly recalculating that top 35 years and making sure it's paying you based on that. You may see individuals who get like an adjustment in their Social Security payments. And the good chance is because they continue to work, Social Security did what they call a recomputation, and based on their work, it did replace one of their low 35 years and did cause a payment change, and their payment increased due to continuation of work. So before we get into benefits for family, any questions about your basic retirement?
And we don't have any questions in the online so far.
Okay. Well, it is Monday. Everybody's probably still getting their coffee, so. All right, so who else can receive on a record? Because you either in your personal life or people you work with are going to you're going to run into scenarios where people are receiving off of somebody's work history. The most common one, and I apologize, I put those back in there. I really need to take those out. The most common one is to a spouse. So the maximum a spouse can receive off a wage earner's record is 50% of the wage earner's unreduced benefit amount. If the spouse files early, that early is 62. There is one exception to that we'll talk about here in a minute. It is early 62, it would be reduced. If the spouse has their own work history, they have to file on their own record first. Then we look to see if they're owed any additional up to that 50% of the wage earner's full benefit amount. This spousal benefit does not reduce the wage earner's benefit. Okay, so keep that in mind. It doesn't hinder their payment at all. There is one other benefit called a child in care benefit. This is paid to a spouse regardless of age. Now, a traditional spouse, your age range is age 62, up through, really, there's no benefit waiting past age 70, okay? There's no increase past the age of 70 for waiting to file for benefits. But for a standard spouse, usually the earliest, other than this example, is 62. Now, this child in care benefit is paid to a spouse regardless of age, as long as they have the worker's child who is younger than age 16 in their care, or there is a child who is found disabled as what they call a disabled adult child, meaning that child was above the age of 18, but found disabled by Social Security rules prior to the age of 22. This spouse, if they are taking care of that child, can continue to receive that spousal payment off that record, okay, if the conditions apply, regardless of age. So keep that in mind. You may encounter that. And the trick with spousal benefits, one thing to note is that a spouse cannot file for their benefit off a wage earner's record until that wage earner or the worker begins collecting. Okay, let me give you 3 real quick scenarios about spousal benefits. Sometimes it makes sense to have examples that kind of clicks a little better. So I have a worker who is refiling at full retirement age for Social Security retirement. They're going to get $2,000 a month. They are also married. It's one of our questions we always ask, are you married? Have you been married to anybody for 10 years or longer? Or have you been married and your spouse passed away? So we're always asking those types of questions. So this spouse is also at full retirement age, and they did not have 40 credits. So they didn't work enough to pay into the Social Security retirement plan to receive a payment on their own work history. So what do we do about that? So what we look at is, okay, the wage earner's getting $2,000 a month. They're at full retirement age. The spouse is also at full retirement age, so they're not insured on their own record. So that spouse is going to receive $1,000. So wage earner gets $2,000, spouse receives $1,000, 50% of the worker's unreduced benefit amount. Now, if that spouse was 62, they would take it at a reduction. Okay, so keep that in mind. Another example, one more common these days, that with workers, again, $2,000, full retirement age. The spouse worked, has their 40 credits, and we're going to look at their work record and pay them $500 off their own earnings record. Well, we compare that to the wage earner's record, and okay, they're entitled up to $1,000 off that worker's record. So what we do is we pay that spouse $500 on their own work record first, then an additional $500 in spousal benefits to bring them up to $1,000. They will be a combined beneficiary receiving off of 2 different records. And then lastly, another common one we see more these days is you again have that wage earner at full retirement age, getting $2,000 a month, spouses at full retirement age, and their benefit amount on their own work record is $1,500 a month. We look at the worker's record, the wage earner's record, and we see, okay, $1,500 is more than $1,000. So simply that spouse will file off their own record and receive on their own record. They're not eligible for spousal benefits because their own benefit amount is more than 50% of the worker's benefit amount. Okay, so I hope that helps in clarifying what the spousal benefit is and how it's paid. Another common one is divorced spousal benefits. So yes, there is the potential that a divorced spouse can receive off of a worker's record. The conditions are you must be married to that individual for 10 years or longer. That's why we ask that question. They cannot be married and receive divorced spousal benefits. Keep that in mind. They have to be the minimum age of 62 unless they meet that child and care condition that I mentioned previously. The difference, really the only difference you're going to find here between a divorced spouse and a spousal benefit is that in the divorced spousal benefit amount, that ex-spouse, that ex-wage earner or worker does not have to be receiving Social Security benefits. They simply have to be eligible. So they have to meet the 62 minimum age requirement and have the 40 credits or be receiving, or eligible or receiving, disability benefits as well. They do not need to be collecting, okay? And the calculation is exactly those three scenarios that I gave you. That's exactly how they apply that to the divorced spousal benefits, right? Now, before we get, I think the next category here, let's see, benefits for children. Let's talk about this and then we'll address some questions you might have regarding this. So children can also receive off of a wage earner's record. That parent who has worked paid into Social Security could either be disabled, receiving Social Security disability or Social Security retirement, or they'd worked paid into Social Security and unfortunately they passed away. So a child can receive, they must be younger than the age of 18, or if they're still in high school, we will pay them past the age of 18 up to either high school graduation or the age of 19, whichever occurs first, okay? So it will pay at least in most scenarios up to graduation or 19. 19 is the absolute maximum that it'll be paid out. But again, it's whichever occurs first to determine how long we can pay them past the age of 18. Now, if that 18-year-old is determined disabled by Social Security prior to the age of 22, and they could receive and continue to receive on that record as what we call a disabled adult child, or you might hear us use the acronym DAC, or we might say CDB, Childhood Disability Benefits. So a CDB, you might hear us use that language. That is all basically, a child was eligible on a record. They are now an adult. They were found disabled prior to the age of 22. Do we have any questions about, these would be considered auxiliary benefits, that wage earner is still alive. The rules all get changed when we go to survivor benefits. Are there any questions about spousal, divorced spousals, or anybody else receiving on a record?
Kim, there is one question. If you are divorced and retire at 64 and full age is 67, can you collect on the ex-spouses and then collect on your own at full age of retirement?
So, and if the ex-spouse is still alive, you cannot pick and choose. It used to be you could. You can't do that anymore. You will have to file for your own first, and then if you happen to qualify for any more on the ex-spouses, then we would pay you as a combined beneficiary, but you cannot pick and choose, as I say. You can't collect the ex-spouses as a divorced spouse and then let yours grow. I should say, if you were born before January 2nd, 1954, and you were at full retirement age, yes, you could. But the Bipartisan Budget Act of 2015 kind of set that rule in motion where now, if you were born after that time frame, you can't do that anymore. So you would have to file on your own first.
Thank you. That was the only question.
Right. Okay, so let's go on to survivor benefits. Now, these rules do change. So if you fell in maybe that scenario, that question we just had previously, the rule's a little different in survivor benefits. So keep that in mind. things change. All right, so a survivor. So this is a wage earner who worked, paid into Social Security, and then they died. So who can receive on this record? A child, again, a minor can receive on this record under the age of 18, or if they're still in high school, up to the age of 19 or graduation, whichever occurs first. That child with a disability who is determined disabled as an adult, but prior to the age of 22, could potentially receive on that record. And the most common are surviving spouses or divorced spouses. So surviving spouse is the most common. The minimum age is age 60. They can file and they would receive 71.5% of the wage earner's full benefit amount. If the surviving spouse is disabled, they can receive as young as age 50 on that record. And that child and care benefit also comes into place where the surviving spouse does not have to meet an age requirement. They can be any age as long as they're caring for a child, the worker's child who is under the age of 16, or that child happens to be a disabled adult child. Now, I will say, let's go back to this really quick. This is in the surviving spouse's scenario, in the divorced spouse's scenario. Then you can pick and choose. So if you were 64 and eligible for divorced spousal benefits, you could receive that. And if your benefit amount based on your own work history, grew, and it grew down the road where later on it was more than your survivor benefit, you could switch over later on. Or you could take your own and switch over to the survivor benefit later on. So you really have some pick and choose there. I will add, though, the annual earnings test does apply to surviving spouses and surviving divorced spouses. So keep that in mind. If those spouses are working and you're under full retirement age, you are subject to the annual earnings test.
Kim, there are a couple of questions regarding
Yes.
children's benefits. One person asked, how are amounts for multiple children handled under a disabled parent? And that was one question.
That's an excellent question. So there is a calculation, and Patty, I'll get some policies on that to send to you so you can distribute that if people are interested in reading more about it. But there is, on everyone's record, there is a benefit amount paid to the wage earner, but then there could be, again, it depends on their earnings, there could be an amount in addition to pay for auxiliaries or survivors. And the amount difference is called a family maximum. So let's say the wage earner, they're receiving $1,000. And then let's say there's 2 children on the record. And let's say the family maximum is $2,000. So the wage earner gets their $1,000, and then the children each would get $500 each. We would divide the family maximum up amongst the number of children on the record. Okay, so there is a family maximum amount calculated in there, and I'll get you more details about that. You'll have it so you can read it yourself on those.
Okay, and we do have a question. If a DAC is collecting SSDI, how will that change when the worker starts collecting Social Security?
Well, the DAC would not be, I'm not sure I follow the question, because if they're already receiving DAC, then the worker's already collecting. But if they're getting SSDI on their own work record, and then let's say they earned enough and they were disabled, but their amount is rather low, and then let's say they were determined disabled prior to the age of 22, and their father retires, we would look to see if they would qualify for DAC on that record. And again, we look at the family maximum and determine if there's, and including what they're working on their own work record to determine how much they would be qualified for on that record. So there's a lot of calculations that go into that. I'm not sure if I read that scenario correctly or not, though.
Well, if the person asking it wants to clarify any further, you can do that. Again, there's another question about, does a disabled child over 18 still in school have choice between disability under the disabled parent's Social Security, or is it better to file under their own disability?
Well, so the only way they could file under their own record is they have to have worked and paid into Social Security. And if that's the case, then, and they were insured, they don't need as many credits. They need a minimum of 6 credits, and it depends on their age. The younger they are, of course. So if they're relatively young and they do have a work history and they're found disabled, they would file on their own first. Okay, we always look for that. The other one is if you're referring to SSI, the needs-based program, Supplemental Security Income, which we will get into here shortly. If that's the scenario, if they qualify for DAC benefits off a parent's record, the SSI rule is they have to file for any other benefits they could potentially qualify for. So they would be required to file for those DAC benefits if they were receiving SSI and they could be eligible on a parent's record.
Okay. And someone asks also for family maximum, how does that change as children get older than 18? Does the amount increase for the children left under 18?
So as the children age out, so to speak, if they don't continue to qualify for a benefit off of that record, and so let's say we go from 4 kids down to 3 kids, down to 2 kids, yes, the benefit amount would change. It would increase children that are on that record.
Great. And one last question so far is, if you are a widow and working for wages above $23,400 in 2025, will the withheld amount, $1 for every $2 above that limit, be returned at FRA? So that, I'm assuming.
Full retirement age.
Yeah. Mhm.
And yes, so if you are in the spousal scenario, but you are subject to the annual earnings test and they do withhold payments from you because of that, you would still get credit at full retirement age for those months they withheld.
Okay. That's it for now. Okay.
Nice. Let's move on. There are a couple quick other survivor benefits before we get into our next category. And one is a lump sum death payment. It is a one-time payment of $255 to a spouse. If there's no surviving spouse that meets the requirements, then if there are children receiving on the record, we could pay it to the child or children receiving on the record. So that payment is limited to who can receive it. Not everybody receives, just because a wage earner worked and they pass away, not everybody qualifies for the $255 payment. The other one is a lesser known benefit, is a parent's benefits. This is if a adult child is working, they paid into Social Security, and they have been supporting their parents who are 62 or older with at least 1/2 of their support. So you have an adult child, let's say they're 45, they are, paying half of the support to their 70-year-old father, and then that adult child dies. That father can go in and claim a parent's surviving benefit off of their adult child and receive off of that record. That 1/2 support, though, has to be proven. So I want to emphasize that if you fall in the scenario where you know someone who does, potentially, if you have an adult taking care of financially their parents, they need to document that, for their safety and security, so that parents would be able to file for the survivor benefit, and have the evidence to prove the 1/2 support. So just keep that in mind. It's not a common benefit, but it is there, and it's good to know about it. Quick compare and contrast here. If you're a spouse, minimum age is 62. Again, that child in care is kind of a unicorn, so just always keep that in mind. In a surviving spouse situation, minimum age is 60. Unless you're determined disabled by Social Security rules, then you can file as early as age 50. A spouse can not receive any more than 50% of the wage earner's full benefit amount when that wage earner is still alive. 71.5% of the wage earner's benefit amount is payable to the surviving spouse if they're age 60. If they're at full retirement age and a surviving spouse scenario, they would get 100% of that wage earner's full benefit amount. Where again, in a living spouse, it's only 50%. That's the maximum. And of course, it's early if they file early. Reduced, excuse me, if they file early. So just a little chart to compare those two types of policies. All right, so we're kind of done with those before we're going to get into disability SSDI benefits and kind of just review that really quickly and then transition into SSI. Do we have any questions up to this point from anything we've talked about?
There's one question is, what are some examples of evidence for surviving parent?
Well, that's a good question. Probably proof that, they've paid maybe their rent. Who's paying that rent, or who's paying the house payment? Who's maybe they're purchasing food, or something like that. Just anything that shows one half support.
Okay.
All right. So SSDI, which is, it's funny because
Wait, I'm sorry to interrupt you, Kim. There's just one more question about how would you apply for surviving spouse benefits when they reach age 60?
You do need to call and make a phone appointment for those. Survivor benefits cannot be filed online, so it does require a phone interview.
Okay, all right.
Sometimes we receive notifications in advance and we'll send out letters to surviving spouses that they may want to look into filing. So you may even get a letter from Social Security to remind you to file.
I'll hold on the next question because it deals with disability, and I know you're going to cover some of this. So.
Yeah, okay. So Social Security disability benefits, I was going to say that externally, the public refers to it to SSDI. Now, oddly enough, internally, we have acronyms for everything. DAC, we have, retirement we'll call RIB, Supplemental Security Income, we refer to as SSI. But oddly enough, we don't use SSDI terminology internally. So it's just kind of ironic to me that the public has grabbed onto SSDI, but internally we don't normally refer to it as that. We simply refer to it as disability. But either way, we do know what you're referencing when you do say SSDI. So this is Social Security disability, and I'm going to separate this from the SSI, Supplemental Security Income, just a little bit, okay? So what is the definition of Social Security disability? It is a pretty stringent definition. So Social Security defines disability as a physical, mental, or a combination of conditions that it prevents an individual from being able to work substantially for 12 months or longer, or the condition is terminal, meaning it would result in the person's death. So when I say substantially, that is referred to as SGA, substantial gainful activity. This is how much this individual's working. So yes, there's that connotation, well, if I'm working, I can't file for benefits or I can't receive SSDI and work. That is not a true statement. However, if you were to call Social Security and say, I need to file for Social Security disability or SSDI, first thing we're going to look at is, are you currently insured? Meaning, have you worked the last 5 out of 10 years from the date of your disabling condition? And then we ask, are you continuing to work? And if you say yes, we're going to look at, are you working substantially? And that's, of course, a wage amount, just like credits work. Substantial gainful activity for 2024 is gross wages of $1,550 or more. 2025, that amount is $1,620. So if you call to file for Social Security disability, we have to look to see if you are what we call currently insured. And then we also have to look at, if you're working, how much are you grossing? And if you call us and say, well, I'm making about $2,000 a month, then we'll ask, do you have any income-related work expenses? We call them IRWEs. See, we use that, an acronym there. These are things that we can deduct from a person's gross wages that they have to pay out of pocket for in order to be able to function, in order to work with their disability. Let's say they have to use specific transportation that they have to pay for because they, can't drive, and they have to have, a special bus come and get them. The cost of that bus they're paying out of pocket for can be deducted from their gross wages when we're looking at substantial gainful activity. So if you call to file for disability and you're working, and let's say you're grossing $2,000 a month, and you have no IRWs, there's no expenses, there's no out-of-pocket expenses that you are paying for to accommodate your disability to be able to work, you will be technically denied for disability. Your case would never go to disability services, who makes that medical condition as to whether or not you meet the definition of being disabled, because you're working substantially by Social Security rules. Now, another scenario is the same thing. You call to file for disability, you're working, receiving $2,000 in gross wages for the month, but let's say you have $600 in transportation costs, medications, you have to have a special monitor for your computer that you had to purchase out of pocket for. That came up to $600. We deduct that from that $2,000 as income-related work expenses, and that puts you down to $1,400 in gross wages. We would take a full disability claim, send your disability case to Disability Determination Services, which we're going to get into in a minute, to make that medical decision. Now, what we look at when determining disability is we consider age, education, and past work activity. And you have to be under full retirement age. The reason you must be under our full retirement age, which again is based on the year you were born, is that Social Security pays an individual their disability payment as if they were able to continue to work up to full retirement age. So if you're already at full retirement age, there's no reason to file, because that would already be the maximum amount you would receive anyways. So keep that in mind. If you have a 70-year-old who has disabling conditions, we still would not make a medical decision simply because they're above their full retirement age. Now, I did mention being currently insured, where retirement, Social Security retirement, once you have your 40 credits, you're good. It doesn't matter when you earn those credits. Your 40 credits ensures your retirement payment. With disability, it's a little bit different. I compare it to car insurance. We look at this currently insured status. So with car insurance, you have to pay a monthly premium or your premiums to the car insurance company, so that if you're in an accident, the car insurance company will pay for the repairs on your vehicle, right? Now, if you stop making payments on your car insurance and your policy lapses and you have an accident, the insurance is not going to cover you because you let your policy lapse. Okay. Same thing applies for the disability insurance status. So if you were disabled back let's say you stopped working in 1990, but you file for disability in 2010. Okay. And your onset is in 2010 for your disability. Well, last time you worked was 20 years ago. You may have 40 credits for retirement, but you're not going to be insured for Social Security disability. You're going to be outside of that window because you haven't worked currently enough to qualify for that program. We do have people who have run into that. They are clearly disabled, but the onset date of their disability happened too far after their work activity. So those things do happen. So just keep that in mind. That could be a scenario if you run into that and going, well, gosh, this person's definitely disabled. But again, why aren't they receiving Social Security disability? And again, it could be that they were outside of that disability window. All right. So to qualify, again, we look at a person's recent work activity, special rules if they're younger. They don't need to have as many credits when they're younger. And then they're eligible for Medicare 24 months from their eligibility for their Social Security disability payment. Okay, so there's a 2-year waiting period for Medicare for a disabled individual, unless they are diagnosed with Lou Gehrig's disease, which is ALS. That's an instant entitlement to Medicare, or they're under end-stage renal disease and they're receiving kidney dialysis or they've had a kidney transplant. Then they waive that 24-month waiting period. Okay, so let's walk through the SSDI process. We've taken an application from an individual. They've worked, they've paid into Social Security, they're recently insured. They're under that SGA, okay? So they're under substantial gainful activity. Once we determine all those factors, then we're going to send all the medical information, what their conditions are, their medications they take, exams and testings, and doctors that they've seen for those conditions. We send those to Disability Determination Services, or we reference them as DDS in your state. So DDS is a state entity, and that entity makes the medical decision as to what determines a person disabled by Social Security rules. They're going to gather all the evidence that they can. If they don't have enough medical evidence to prove the disability based on the criteria that we have, they will send the individual potentially for what we call a CE, a consultative exam. This allows a third party to examine the individual and to note, do the disability conditions. And so we'll use that as additional evidence to support the claim if need be. You don't always have that case. If evidence clearly shows the disabling condition, there's no need for a consultative exam. Now, where's all the rules behind what makes someone disabled by Social Security's policies? That comes from our Social Security Blue Book, okay? And there's a link there. If you click on that, you have to have it in presentation mode, but if you click on that, it'll take you to the Blue Book. You can order one or you can do it online. Online, you have a listing. It could be, let's say, diabetes. Diabetes, you can have varying levels of diabetes. So you can have a diabetic who's able to manage their blood sugars and be able to keep it manageable and work, and therefore would not be considered disabled by Social Security rules. But you also may have the diabetes that is not manageable. It's, fluctuates significantly. Maybe they've even had a foot amputation or blindness or something like that caused from the diabetic condition. And that person could be qualified for Social Security disability. Same condition, same diagnosis, but very different outcome when it comes to a medical decision from Social Security. And the rules that the DDS examiner has to look at come from the Social Security Blue Book. Okay. DDS is going to look at, are you working? Is your medical condition severe? Do the impairments meet the medical listing? That's that Blue Book that I just talked about. Can you do the same work you did before? Can you do any other type of work? Can you be cross-trained into any other type of work? They look at age as well as a factor. How old are you? I always, I'm based in the West Virginia area, and so I always think of the coal miners. If someone has done coal mining for 30 years, they're in their 50s, they have an accident in that mine, and let's say they have a leg amputation, that person is probably going to be more likely to be approved for disability than someone who is younger, maybe has a different education and maybe can transition into another career field. So there's a lot of factors when looking at the medical decisions. Now, once that state agency makes the decision, and if it's approved, they're going to send you a letter, and it tells you the amount of the benefit the monthly benefit you will receive. It's going to tell you your reporting responsibilities and things of that nature. We can do that with SSDI because we already know your monthly benefit amount if you're approved, okay? Because it's based on your work history. If you're not approved, if you're denied, we tell you how you can appeal that decision. And I'm going to go through a whole section on appealing disability decisions here in a little bit, okay? Now, if someone's found disabled, that worker's disabled by Social Security rules, other family members could receive off that record, okay? A spouse, if they're age 62, or if they have that child in care qualification, even divorced spouses may qualify if the disabled worker's receiving. Again, children under the age of 18, unless they're still in high school, 19 or graduation, whichever occurs first, and then that disabled adult child could receive off of that record as well. So keep those in mind. You very well could be working with an individual who's receiving off of a parent's disability record. So any questions about SSDI before we transition into SSI?
Yes, Kim, we have a few questions. One question is, if you feel you're not getting correct disability amount, what's the best way to appeal it?
Well, one, the amount should have been addressed at the time. So if we're saying if you receive a letter that says you've been approved, this is the amount that you're expected to receive, and you disagree with that amount, you have 60 days to have someone, go in and double check those calculations. So an appeal is, you can do it online or you can fill out paperwork. And the first level, I'm going to get into the appeals here in a minute, but the first level is a request for a reconsideration. And we'll talk about those steps in just a few minutes.
Okay, and then there's a question, how long after being approved for disability does a person have to wait before trying to work again?
So Social Security cannot, and I do a 2-hour presentation on how work affects benefits across the board. Social Security cannot tell an individual to work or not work. Okay. We can't tell you how much to work or how not to work, but what we do tell you is how the rules affect you. So there is no waiting period to begin working. If you're working under SSDI, though, as soon as you start working, you're kind of enrolled in something called a trial work period. This is a 9-month rolling period that allows you to try out work. If you make above a certain amount, they would count it as one trial work period. You get 9 of those. They don't need to be consecutive, okay? So you could work, quick example, person's disabled, they start back to work. It doesn't matter when, okay? They start back to work and they're going to gross $1,200 a month for the first month. That month is greater than the trial work period amount, which I want to say it's like $1,020 or something right now. I'd have to look that up. But let's say we're in October, they earn $1,200, they're above that trial work period limit amount. That's one trial work period. November, they only make $800. It's below the trial work period amount. So in 2 months, they've only worked one trial work period. Let's say they go 4 more months, they're still below. Okay, in 5 months, they've only used one trial work period. Let's say the 6th month, they go back to $1,200 a month. In 6 months, they've used 2 of their 9 trial work periods. Now, once they've used all those trial work periods, they still get their Social Security disability. That doesn't stop, okay? This is allowing them to try things. Then they go into an extended period of eligibility, or EPE is what we call it. And this is a 36-month period where if an individual is above substantial gainful activity, do you remember that SGA I talked about in the beginning? For every month that they're working, that they're above that, their check stops. They don't receive payment. If their check's below that, they do receive payments. That can continue up to 3 years before their benefits stop, okay, due to work activity. Now, once, let's say their benefits stop, you have 5 years from the last time you were eligible for SSDI, 5 years. If you have to reduce your work activity, meaning go below that SGA amount, or you had to stop altogether due to the conditions that made you disabled to begin with, okay, it's got to still be that disabling condition, you can ask for an expedited reinstatement. Expedited reinstatement states that you come in, you're below SGA because of your condition. We pay you 6 months of provisional payments while Social Security disability continues to, or makes a new medical decision to determine if you're disabled or not by the rules. I hope that helps. So you can work. There's no real time limit of starting and stopping. It's just a process and communicating with your Social Security office so you know how the rules affect you.
And actually, I think this question is related to the trial work period. It says, isn't it 9 months of a 60 rolling month period?
Yes. So good question. If you have 9, you get 9 of those trial work periods. Again, they don't need to be consecutive. If you, let's say, use 3 of them, but after 5 years, if you did not use all 9 within that 5-year period, then it resets.
Mhm.
You start over.
Great. And someone asked about, do self-employed individuals automatically pay into disability when paying taxes?
No, they actually have to make sure, well, if they're paying Social Security taxes, They have to ensure when they complete that out that they're paying their 15.3% of Social Security and Medicare taxes.
And the last one is, do people have to submit 2 separate applications when applying for SSI and SSDI? If a person is qualified for SSI and later earned enough credit for SSD, can the old SSI disability application be used by the SSA representative?
Okay, so, and we go back and forth a lot on this. So if an individual was receiving SSI, which is what we're going to talk about next, and they're working, they're paying, and that's another good thing about working, and they're paying back into Social Security to become insured, okay? So they're getting their credits and stuff like that, and they have a disabling condition. At that point in time, as soon as we see that, oh, they've got enough credits, we need to take a new disability claim. So there are times when we can adopt a disability decision, and there are times where we actually have to make a brand new disability claim on that. So it does, in your answer to your question, it does require an additional application either way. But sometimes we can adopt that medical condition, and sometimes we have to send it back to disability services to make a new medical decision.
All right, I'm going to hold on this next question. This is related to the appeal period again. So I think you were going to talk further perhaps about the appeal.
Yep, we're going to get there. As soon as we're done with the SSI portion, we're going to go into the appeals.
Okay, thanks.
Great. So supplemental security income, you probably already know this. We refer to that as SSI because it's a whole lot easier to say. That is our needs-based program. This looks at factors of if you were under the age of 65, you must be found disabled by Social Security rules, or maybe you have blindness. You're considered what they call statutory blindness, and have limited income and resources. Children do qualify as a disabled child under the SSI program, where if you notice, unless you're an adult, we do not find children, minor children, so under the age of 18, do not receive disability payments on the Social Security side of things. Because if they qualify, they just qualify because they're eligible as a minor on that record. It's not until they reach 18 that we address the disability factor. So if you have a 6-year-old receiving, and the parent says they're receiving disability, they're receiving SSI, okay? Because we don't find children disabled under the Social Security program until they reach the age of 18. If you're an adult 65 or older, we do not need to determine disability, okay? We're not going to take a disability claim. We simply look at limited income and resources. This is our needs-based program. It is a federally funded program paid out of general tax revenues. It does not come from the Social Security Trust Fund, okay? This program is designed to do exactly what the main title is, supplement someone's income if they meet the qualifications. We do have many individuals who receive both Social Security and SSI because their Social Security payment is below the SSI federal benefit rate. And payments for SSI are issued on the first of the month. So when we look at income, so when we're screening for someone who is applying for SSI, first thing we have to do is we have to look at, do they meet the income and resource guidelines first? We will not go into the disability portion on the SSI claim if they're above income or above resources. Now, when someone calls us to file for disability, we will always screen for both. Are they insured for Social Security on their own work record? We also address the needs-based section in limited income and resources, unless they say, I don't want to file for SSI. If they clearly state that or state that in the online application, then of course we won't take the application. But normally we screen for both unless they specifically tell us not to. So wages or earnings, what are we going to look at in earnings? We have earned income, which is referred to as either wages, self-employment, things of that nature where a person's going out to work, okay? Then we have unearned income. This is SSI payments, veterans benefits, unemployment, things of that nature. If it's a child getting child support, that would be considered unearned income. These are counted very differently. Again, I do presentations on how do we look at this? How do we calculate their payment amount for SSI? Because it is needs-based. And if they have other income, it does affect their payment amounts each month. So just we look at these different types of criteria when they're calculating, are they eligible? So if a person, the SSI benefit rate for 2024 is 943. If an individual is receiving, let's say they're filing for SSI, but let's say they're already receiving Social Security benefits at a rate of $1,000, well, they're not going to qualify for SSI because they're above that benefit rate of 943, okay? Because SSA, other than a $20 exclusion on unearned income, it's counted dollar for dollar, except for child support. That's a different scenario. So excluded income, what are we not going to count? Sometimes it's not necessarily financial. Food stamps, we don't count food stamps. That's excluded. That doesn't, reduce their payment at all. Income tax refunds are excluded up to 12 months. That's important to keep in mind if someone is filing, and they had an income tax return of $6,000 sitting in their bank account, we can exclude that up to 12 months, okay? Assistance under the medical or Social Security program, like if you're getting aid in attendance through the VA, certain types of housing allowances, certain types of housing assistance can be excluded, meaning it would not count as income towards the individual. In some SSI scenarios, if an individual is, let's say, a friend is paying their rent for them, that can be considered in-kind support and maintenance, or ISM, and that would reduce their payment because someone else is providing that essential need for them, putting the roof over their head, they're paying that for them. We reduce their payment amount, okay? But there are some programs out there where we would exclude that and not count it as a form of income. Resources. Now, the limit for an individual is $2,000 in assets. So that asset could be non-home property. It could be money in a bank account. It could be stocks, bonds, additional vehicles, things of that nature. For a SSI couple, it's $3,000. So if you have, what we do include, what we would count as a resource would be your standard bank accounts, your stocks and bonds, multiple cars. We exclude the highest valued car you have. And then we look at the value of the other cars to determine if you're above the resource. A life insurance policy, if it's term, it doesn't count because there's no cash surrender value. But if it's a whole life policy that does have that cash surrender value attached to it, we will count life insurance. And then non-home property other than where you live, we'll count that. Now, the home you live on and it's like extensions. So if you have lots of acreage and stuff and you have extensions on that property, we would exclude that. Your first highest valued vehicle, burial plots for self and family, we can exclude that. Some resources set aside for burial purposes, we can exclude a certain amount for that purpose. You have to kind of earmark that and tell us that's what that's for. And then ABLE accounts, achieving a better life experience accounts. These are they're about 10 years old now. This is a sheltered resource where an individual can have up to $100,000 in that account, and it would not count as a resource against them. Other things we look at with SSI is living arrangements. So living arrangements are where the person is living, just like that. So if they're living in someone else's household, we have to develop for potentially sharing. Are they paying their share? Is this a public assistance household, which we're going to get into when we talk about the new updates with SSI? If they're living alone, are they getting assistance from other sources, or are they paying their own way? If they're in an institution, like a hospital setting, it could be that their benefit amount goes down to $30 a month. Some group care boarding facilities could affect their benefits, just depends on where they're at. If someone's incarcerated 30 days or more, They are not payable based on their living arrangement. So for SSI, just the federal benefit rate, this is what Congress has set as the marker, the maximum an individual can receive in SSI alone by itself. If they have no other form of income coming in, they're paying their own rent or, mortgage and their utilities, is $943 a month this year, $1,415 for a couple. Next year, it will be $967 a month. And for a couple, $1,450 per month. SSI is tied to Medicaid, which is the state health insurance program. So if they're getting $1 in SSI, they're entitled to that Medicaid card. There are some work provisions. One of them is called the 1619B provision, which states that if wages are the only thing keeping an individual from receiving an SSI payment, and they're under the state threshold for income, they can retain that Medicaid card. Okay, and we keep the record active, and they can still retain Medicaid eligibility based on being SSI eligible but not payable. So there are circumstances for that as well. SSI beneficiaries must apply for all benefits they could possibly be eligible for. So we screen if we feel that an individual, they served in the military, are you eligible for VA benefits? You need to apply. You don't have to be approved, but you have to show that you applied for that benefit. So whether it's VA, we look to see if they qualify on Social Security as far as spousal benefits could go. If we do a review on someone's SSI record, which is, we call it a redetermination. That's where we look at an individual's income, resources, and living arrangements. We bring everything up to date. If we look and see they've been working and they're insured now, we may take a disability claim on the SSDI to see if they qualify for that. So we're always looking, and the individual is required by law to apply for any other potential benefits they could qualify for. Children under the age of 18, like I said, must be determined disabled. Again, they have to meet the income and resource guidelines as well. We do have to look at parents' income when determining whether a child qualifies for SSI payments based on parents' income. We do have a deeming chart that shows, if a parent's working and the child is found disabled, at what wage limit would their SSI payments start being reduced, and when would their SSI payments stop? If you'd like that, I can certainly send you the 2024 deeming chart for you to look at. And then again, the same medical conditions has to be something that's going to last at least 12 months or longer or be terminal. In SSI scenarios, the same DDS applies the same procedure. Okay, if we screen an SSI individual or a person applying for SSI and they meet the income and resource guidelines, we then at that point in time take the disability portion of that claim, send it to DDS. DDS does their standard review of the medical evidence, makes that medical decision. Now, I will say the adult decision that DDS makes for an adult is the same, whether it's SSDI or SSI. The criteria of being disabled is that blue book. Okay, that's the gold standard. The children, there is a different set of rules for disabled children. Okay, so just be aware of that. When they turn 18, however, we do have to do a brand new medical decision on children to determine if they're still disabled based on adult criteria. That's called an age 18 redetermination. Now, once the state makes the decision, they're going to send a letter saying you were determined disabled by our rules. Social Security has to contact you to update your application to determine if you're payable for SSI benefits. And the reason being for that, we can't tell you the benefit amount because it can take anywhere from 3 to 6 months to make a medical decision on somebody. A lot can happen with an individual's income and living arrangements and resources during that time. So we have to update the record at that point to determine how much they were eligible for and payable for. And again, if not approved, appeal rights are in that letter. I just mentioned this at age 18. If a child was already receiving SSI benefits and they turn 18, we have to do an age 18 redetermination. We have to determine if they're still disabled based on the adult rules. We will at that point in time no longer count parents' income and resources for eligibility. If the child is still living with the parents, we have to develop, are they paying their fair share, or does this meet the definition of a public assistance household? Because we have to look at them individually now and to make that decision if they can continue to receive payments. Now, we do have children who are clearly disabled as a child and they turned 18, but they never received SSI because their parents' income and resources were too high. I encourage that, parent to have that child file at 18 to see if they qualify for SSI now, that we no longer count the parent's income. So it's another thing to think about as they turn that magical age of 18. All right, that's the SSI kind of, and again, these are streamlined basics of these programs. There are any questions pertaining to the SSI portion before we get into how to appeal the disability decisions?
So there's a question. The person says that they work in special education. So if I understand you correctly, a parent's income would be counted as a resource for the child in determining if they can receive SSI. And again, clarifying, that will be a child under 18. So if a family meets the income guidelines, then the child could receive SSI, and that's a question. Or he also added another add, if over income, the child would not receive SSI.
Right. So if you have a minor under the age of 18 with some disabilities, we have to look at mom and dad's income. If they're living with the parent or parents, we do look at their income when determining eligibility and resources as well, of course.
Right.
So we look at that. As they approach 18, if they're under that scenario, we encourage, them to file at the age of 18 to see if they're disabled as an adult for the SSI program.
Excuse me, Kim, I'm sorry. It is important, I think, to clarify, though, that child, even though they're not getting a cash payment from SSI, still may qualify for medical assistance in the state of Pennsylvania because of the loophole, and may be getting Medicaid.
Yes, there are some scenarios. I've taken applications where the parent clearly knows we will be disabled or we will be denied because we're above the income guideline for the SSI program, but I need proof that I filed.
Right.
And that is for the other potential health benefits for the whatever state program that they're filing under. So that's
Right.
true. Absolutely.
So, and then someone else asked about why the $3,000 limit for couples. Says if a person qualifies for SSI individually, why should their spouse's income not? I don't think that. Why should their spouse's income matter? Isn't it a good thing if the spouse works and $3,000 a month is not that much? I think $3,000 a month, just to clarify, I think you're talking about assets, are you not?
Correct. That $3,000 is the asset limit. Yes.
So it's not monthly income.
Correct. It's a resource. It's money in a bank account. It's a countable resource. So it's money you have access to. The SSI program had to set a guideline to determine what is the appropriate resource amount, because it is a needs-based. This is basically you have exhausted other measures, of supporting yourself. So they had to come up with some form of limit, and they had determined that, $2,000 for an individual, $3,000 for a couple. Now, if you're talking parent-child, that's another thing as well. If, let's say, you're filing for a child for SSI, and they're living with their parents, and we're looking at resources. The parents, we're going to look at, they have to be under that $3,000 asset limit. Okay. But if they're above that, let's say it's $4,000, we can deem, a more than $1,000 down to the child and count that as the child's resource to make that child qualify. Putting the parent's assets under $3,000, the child, if they, we deemed down, so to speak, that asset from the parent to the child, and the child's under $2,000, if that makes sense. Okay,
And
so
on
that types of eligibility factors from that point as well to see if we can get, a medical decision made for that child.
Gotcha. And on that matter, someone did ask about sending the deeming chart, whether that's something that, how do they access the deeming chart? Would you send that to Patty?
I will send that to, yeah, I have a note here to send that to you all.
Excellent. And then someone asked about NICU babies, I guess premature babies, in terms of, I assume, as it relates to applying for SSI.
Yes. So normally, so most hospitals, we do have a partnership with most hospitals, and these are usually what they reference low birth weight babies. If they would be what they call presumptive cases. So these, we get a referral from the hospital stating that there is a baby that was of low birth weight, and there is a criteria for what meets low birth weight by gestation. If they fall in that range, we set that record up. As long as they're still hospitalized, we set the record up. We get them into pay. We still make a medical decision that'll still go to disability services, but we go ahead and pay them that $30 a month. That's that institutionalized pay based on the living arrangement and their presumptive condition of being a low birth weight. But we do that so they can get that Medicaid coverage. They can get that access to Medicaid, because as we know, the NICU babies, that can add up very fast for parents. As soon as let's say they are approved, they're continuing to get payments. As soon as they're discharged, we do have to do a review with the parents, because at that point, as soon as the child is home, we have to make a new redetermination based on parents' income and resources. But yes, that is something that applies. And there also could be a presumptive NICU condition outside of low birth weight that we look at as a case-by-case basis, but most of them are associated with being affiliated with low birth weight.
Okay. And actually, this question, I think, is related to that, applying the whole question of the loophole. It says follow-up special ed, a minor can stay to age 21 to 22. Do you still encourage applying at 18, or did they wait? Just thank you. And yes, no about the loophole. So I think if I understood this, I think the question is, if the child has been under the loophole all along, not receiving cash, but MA, do they still have to apply for SSI at age 18?
Well, they don't have to, but if they have, a definite disabling condition, I would encourage that, because then they might at 18 be eligible for actual payment.
Right.
And then they could go into, that opens the door for vocational rehabilitation services and other types of expansion services that would potentially be open to them. And I know they're under that same loophole, but that magical 18 is a good time to get that formal Social Security diagnosis, decision.
Right.
Another reason you would want that is a future DAC benefit. Let's say, you have a child 18, if they're determined disabled prior to the age of 22, and they're still disabled, this is something maybe they were born with, and then let's say they're 40 and dad retires and gets Social Security, there's the potential that adult child now, even though they're 40, we made that medical decision prior to the age of 22, can get DAC benefits off of that retired parent now. So there's other potential future benefits that having that decision made early enough could help them.
Okay. And then we have a question: if a person received SSI and then, based on their work record, started receiving SSDI and are still working under SGA, does the trial work period still apply?
It would, once they receive, yes, once they start receiving, once they're eligible for the SSDI, that's when we would start applying the trial work period.
Okay.
Now, I do want to mention, this is something that's, there are circumstances where we have individuals who are receiving SSI, they're working, they are insured, they worked enough to pay into that Social Security to be qualified for SSDI. However, they may not be payable because they're SGA. So SGA only applies for SSI when they initially file. After that, we don't ever look at it on the SSI side of things. But on the SSDI, we always look at SGA. So we have people, SSI beneficiaries, receiving payments on SSI, working above the SGA limit. They're insured for SSDI, but they're above SGA, so they cannot file on that SSDI record. I know that sounds so counterintuitive, but that's that is a possibility too. So yes, but yeah,
And-
count the trial work period as soon as they start being eligible for the SSDI.
Thank you. And this person says, one of my members was approved for SSI, but her husband makes more than $3,000 a month. Actually, he makes $3,500 a month. So she was approved, but cannot collect. Why is that?
So we could have found this person medically disabled, but we count husband's income and we look at that and determine the income amount. And if they're, above the income limit, then they wouldn't be payable. In addition, if they have money in above the $3,000 resource limit, they wouldn't be payable. So they could have filed at the time they filed. Another thing is they could have filed and maybe the spouse wasn't receiving as many hours. Maybe they were under the income limit and then maybe they got a raise during the waiting period or something like that. We don't know. There's a lot of scenarios there. We'd have to look at the case by case and see what happened.
Okay. So yes, that's it for the SSI questions. Again, well, we do have that one appeal question, but you're going to be talking about that now.
Yep. SSI, as you notice, there's a lot of moving parts here. Lots of moving parts. So when appealing a decision, anytime you get a formal letter from Social Security, I'm going to focus on disability appeals. However, appeal in general, you disagree with the decision Social Security has made on your record. So it could be a non-disability appeal or it could be a disability appeal. So, but for this purpose, for disability determination services, when they send a letter out, if they state that you do not meet the qualifications for being disabled by our rules, they give you 60 days to appeal that decision. They do allow 5 days of mail time. So you can say you have a 65-day window to submit your appeal, meaning you disagree with Social Security. There are 4 levels. The first one is a request for reconsideration. That level, the appeal's taken and it goes back to disability services. DDS has a different examiner review the information and determine if you are, if you meet the qualifications or not. Okay, someone else looks at it, a different set of eyes. If that comes back and that is still denied, your second level is a hearing by an administrative law judge, okay, an ALJ. This is where you actually can, if you choose to, appear before a law judge in person. They do video conferencing now with these as well. You can do a phone hearing as well. And the law judge makes the applicable decision as to whether or not you meet the definition of disability. If that is denied, your next level of appeal would be a review by an appeals counsel. Appeal counsel examines the information and makes a decision as to whether to uphold the law judge's decision or remand the case back to the hearing level. Maybe they feel that law judge needs to review some other medical evidence, or maybe there's something else that needs to be considered. So there's a potential that it could be sent back to a hearing, and we call that a remand. And then if the appeals counsel says, nope, you are still not disabled by Social Security rules, your last resort would be federal court review. This is actually where you sue Social Security as an agency. The only time you need representative and the only time you need an attorney, so to speak, for any of these appeal levels is the federal court review. Okay, that is required. All the other ones you do not need representation, although you have the right to representation. But please make sure you have that 60-day window. They do at times, if you're past this window, they do have good cause for late filing, but you do have to justify why you were late. Perhaps you were hospitalized during that transition period or things of that nature. So keep that in mind. If you're outside this window, but you have a good cause for that, still try to file that appeal and see if we'll accept that good cause for late filing.
And Kim, I think that answers this person's question. She's saying if you're out of the 60-day appeal period, you now understand you should be receiving a higher amount, or circumstances changed, how do you appeal the original decision?
Yeah, you can do that and explain. You have to explain why you're outside that 60 days. Yeah. You can file your appeal online. Both medical and non-medical appeals can be done online at ssa.gov. You can call us to send you the forms. We can send them electronically. We can mail forms to you to appeal those decisions, and you can send them back to your local Social Security office.
Someone did ask, by the way, Kim, this is just a side issue, where they can find the other presentations that you referred to, that you do provide, more in-depth on certain topics.
I mean, if you have a specific one, maybe like how work affects benefits, they're lengthy, I'll tell you that. But I can send you one if you prefer. Just let me know what topic you're interested in. And
maybe this person can tell us what they might be interested in. I can let you know.
All right, let's move. So here's just a quick comparison here. What's the difference between SSDI and SSI? SSDI is based on it comes from the Social Security Trust Fund, based on the worker's earnings. They paid into the Social Security program through taxes on their wages. The benefit amount, again, varies depending on their earnings. It's not dependent upon income and resources. And additional people can receive off of that record if they qualify, like a spouse or a child, okay? SSI is a needs-based program. It does not come from the Social Security Trust Fund. It is affected by income and resources. It looks at factors. If you're under 65, you have to be found disabled, and those limited income and resource guidelines you have to meet. And children can be found disabled under the SSI program who meet limited income and resources. So just kind of a compare and contrast here. All right, we're going to so that's pretty much our basic programs. Those are the big ones, okay? And that was just really, I know we've been sitting here an hour and a half, so in just covering the basics, there's a lot with it. I'm going to transition to some basics like our online services really quick. We're going to talk real briefly about the new updates with 2025 and things of that nature. But pertaining to the programs that we already mentioned, do we have any last minute questions that I can address?
And I think, Kim, this last one is, an important one. And actually, I've heard this situation in the past. And this person says, my wife began receiving Social Security retirement in March, which triggered a disability review for my son to receive SSD from her work history. My son, aged 32, is receiving SSI, and I filed a Form 3368 disability report adult for him, which established his disability before age 22. He has delusions, paranoid schizophrenia, which prevent him from joining a Zoom call with the IMA group doctors to evaluate his continuing disability. His delusion was that he did not need to join the Zoom, again, because his doctor told him not to join the call. Dr. Oppenheim is a psychiatrist who died several years ago. So he obviously did not say that to my son. I explained that to Dr. Perry. I'm a group on the Zoom call. He watched my wife and I pleading with my son to take the phone and join the Zoom. He would not open his bedroom door, did not take the phone, or even speak to us to say no. So his disability is preventing him from establishing his disability. What can we do to correct this catch-22 situation?
And he was already determined disabled for SSI purposes, correct?
Yes.
But
yes.
And he's now an adult, and is he continuing to receive the SSI payment?
Can't tell by this. Can the person who asked this clarifies whether, let's see, yes, he is. He's continuing to receive the SSI.
Yeah, so if I don't know if a medical decision, these are case by case basis, and I don't know if a medical decision was actually rendered denying him the benefit off of the parent's record, or if they needed to establish that disability prior to the age of 22, are they lacking medical evidence at that date? That's another thing we have to look at. This might be something, if you would like to, just for the sake of time, if you would please email me and give me your contact number, and I would call you directly. That way we can get into the nuances of it.
Perfect. Thank you. But it is a situation that, frankly, I've heard of before, and it makes it really difficult.
They have to have, I mean, we have these parameters and these
Yeah.
dates and these guidelines, and then evidence has to support it within that time period. And if they're searching for a specific, we've got to see this, this, and this within these dates, and they don't have that evidence, that's when they set up these consultative exams. And sounds like they tried to do a video call that did not go well due to the condition, which I understand that. Perhaps, we can have, perhaps there's, would the individual be, can they set up an office type scenario where they go into an office for an exam, something like that. I mean, we have to have our criteria, but maybe we can take signed affidavits, from community members, things like that, regarding the situation as well. So let's look at that on a case by, that's something that's very specific. Some things that we need to look at and work with the local Social Security office to see where we can go from here forward.
And we did have two other questions that came up. Again, this person says a worker wants to take disability at age 62 after working many years and has developed a disabling condition, was told she could receive what she would receive at full retirement age. How should she proceed?
So if you're already at 62 and you have your 40 credits, you have a couple things you can do. You can file for retirement, start receiving that at a reduced rate, because filing early, you're under that reduction factor. But in addition to that, if you have a condition which led to your physically, no longer working, you have conditions, you can also file for disability at the same time. It's called a RIB-DIB. If you are approved for the disability portion, what they would do is increase your payments to that full retirement age amount. So I would, if you feel you fall into this category, file retirement and disability at the same time. The retirement is easier to process because we don't need that medical decision or anything like that. So that would get you some payments going while we make a medical decision.
Huh. Interesting. And the last question was, when an SSI recipient stops working due to their impairment, how do they regain benefits?
Oh, excellent question. So there's a couple things around this. So it depends if their SSI payments stop due to work. Normally, if an SSI record is suspended for 12 months or longer, that record terminates. An individual has to refile all over again if a SSI record terminates, okay? So a non-payable SSI record for 12 months or longer, the individual would have to reapply. However, you mentioned working. So here's a scenario where that 1619B provision that I alluded to earlier might have kept that record active. So this would be, the scenario is they were SSI eligible, they began working, they got to the point where they were no longer payable for SSI due to their wages. The rule is if wages are the only thing keeping you from receiving an SSI payment, and you're under the state threshold, which is determined by the state DHS, you can keep your SSI record active. It's not payable, but it's active, and that would allow you to retain the Medicaid. So in that case, if this person falls into that scenario, even if it's been 2 years, they can come back in and say, I stopped working, I've reduced my wages. And if they meet all the other income resource guidelines, we could put them right back into pay. Okay? If it's truly a terminated record, meaning it went 12 months or longer, didn't meet that provision, then they have to reapply, like starting all over again. If they're under 65, we've got to do that income resource guidelines and then make the medical decision through DDS.
Okay, and we did have another question that did pop up. Is there a chance that you can receive early retirement Social Security, apply for a disability, and not be approved for disability? Is there a document that medical providers can refer to so that that does not happen?
I mean, there's always the chance they can say you don't meet the medical criteria. So I'm not quite sure what you're referencing. They still have to, even if you're receiving retirement or you've already retired, but you have disabling conditions, they still have to, do the medical evaluation.
Yeah.
And you still have to meet those guidelines.
Okay, that's good for the questions.
Okay, so really quick, let's visit. Online is our best place to receive information and news about SSA.gov. Please make sure you are on SSA.gov. You can do that. It's written here. Ways to know it's secure. You have that little lock to the left, means you're safely connected to our website. And of course, our official website is .gov. .nets, .coms, .orgs may contain Social Security information, but we cannot guarantee the accuracy of that information. So don't rely on those sources when you're trying to obtain Social Security information. Hopefully, if you have not already done so, I encourage you yourself on a personal level to create your My Social Security account. This is your personal account with Social Security. It allows you to review if you're not on receiving benefits. It allows you to do some planning. It's going to tell you how much you would receive for retirement, disability, what your family could receive in survivor benefits, shows you your work record. You want to make sure that's correct when we're talking about your top 35 years. It's also going to show you how much you've paid throughout your work life in Social Security and Medicare taxes. So I encourage you to create that. If you're already receiving benefits, it's going to allow you to update your address, get proof of benefits, change it, set up your direct deposit, get your 1099 at tax season. In addition to that, either way, whether you're receiving or not, if you have a valid driver's license or state ID, you can request a replacement Social Security card behind your My Social Security portal. Therefore, you can do it all online, never leave your house, and you don't have to go into an office to get the replacement card should you need it. So I encourage you to do that. They have switched from the traditional sign-in platform directly through Social Security to login.gov or id.me. So if you created your account before September 18th of 2021, go ahead and reset that. You want to go in with your normal sign-in username and password, and it's going to redirect you to log in and create an account through one of these other platforms. You can also start the process of requesting a replacement Social Security card online. So you don't have to have a My Social Security account. You can request a replacement card. You can update your information. By either scanning the QR code or clicking the link, it's going to take you through the few questions that you have to answer, and then it'll allow you to submit the application. At that point, then you can go visit your local office, check in. As soon as you check in, it's going to recognize that you're requesting a replacement card. All they have to do is verify your identification, and then they can get that card ordered for you so you can receive it in the mail in 7 to 10 days. So it just speeds up the process of going into an office if you have this application already pre-done and pre-submitted. Sometimes people want to know what kind of identification. I've noticed a lot of our organizations and agencies, they're really trying to help their clients, and eliminating some of these barriers. So when we need identification for a Social Security card, 9 times out of 10, that's all we need. It's proof of ID. There's different biographical information that we're looking for. So we don't need proof of age unless there's a date of birth discrepancy on the record. A lot of individuals think their birth certificate is sufficient for getting a replacement Social Security card. It is not. So once you've already been assigned a number, we've usually already verified and established that date of birth. So therefore that type of identification is not proof of identity. It doesn't prove you currently exist. So we first go with primary proof. This is evidence that we must have if you have it. A U.S. driver's license, a state ID card, a U.S. passport, or an employee identification card. We're looking for a name, date of birth, preferably a picture as well would be helpful. If we don't have that, we can look at a school identification card, a health insurance card that has name, date of birth, and an issuing date or an expiration date. We can't use our own evidence, so we can't use our own Medicare card as proof of identification. And there's just some listings here of different things you might find helpful. If you are working with an individual who just has absolutely nothing, nothing on these listings at all, most of the time they can use what we call certified medical records. as proof of identification. They can go to any doctor, clinic, office, ER, dentist, eye doctor, where they have been treated and get a copy of their medical records. It's not the invoice, not the bill, but it has to be evidence of the medical record, has to show their name and date of birth on that or age, and it has to be certified, meaning it has to be stamped or signed off by the issuing agent, verifying that, yes, this is the person that came to get this information. So I just want to put that out there. Hopefully that will be helpful for you. 9 times out of 10, if people have absolutely nothing, medical records are the way to go to get proof of identity for a replacement card. All right, so we got about 15 minutes. So real quick, let's do some updates, some recent changes with Social Security. The cost of living adjustment came out. It's a 2.5% increase that's going to occur in January. So the maximum taxable Social Security earnings is, so your wages, there is a cap that your wages are taxed out for Social Security purposes. In 2024, it was $168,600. 2025, it was $176,100. Well, it will be. There's no limit. Medicare is taxed regardless on all wages. And a quarter of coverage. Remember, we talked about the credit. You need 40 of those. It's $1,730 this year. Next year, it'll be $1,810. The earnings test we already talked about will go from $22,320 up to $23,400, $59,520 up to $62,160. And just some other things, we already even discussed the SSI. So I've incorporated all of this in here. Your SSI benefit amount rates increase there. SGA. So we did talk about that magical number. For a non-blind individual, it's $1,550 a month, and it will go up to $1,620. If the person is statutory blind, it would be $2,590 up to $2,700 for the SGA limit. And there's our trial work period. I was wrong. So it is $1,110 per month this year. That's constitute any earnings above that is a trial work period month. It's going to go up to $1,160 for 2025, which would be considered a trial work period month. One of the biggest changes that came in 2024 with our new commissioner, Martin O'Malley, is regarding our overpayment process. You, working with the agency you work for, are already probably familiar with what an overpayment is, but in case you aren't, at times, certain Social Security and SSI individuals can receive too much money they weren't actually due from Social Security. So that's considered an overpayment. We do send a notice to the individual letting them know they've been overpaid, the reason they're overpaid, when it occurred, and the process of either appealing it, meaning you disagree with that overpayment, it's wrong, it's not correct, we got you all wrong. You can appeal that. Those are those forms I talked about earlier. You can do a request for a reconsideration on an overpayment, or you can apply for a waiver. A waiver states, okay, there very well might be an overpayment and it might be correct. However, I can't afford to pay it back, or I need to reduce the amount of the overpayment repayment plan. Okay, that's what a waiver does. A waiver doesn't disagree with the overpayment, but a waiver states a way that you can manage either paying it back or seeing if Social Security can waive it. The process of a waiver means you cannot be at fault in generating the overpayment and you cannot afford to pay it back. Okay, that's the one to have it completely wiped away. There is a waiver, though, to reduce your payment plans as well. So real quick, you notice here on the slide, it used to be, we used to have something called an administrative waiver, which meant that if you had an overpayment of $1,000 or less and no fraud was involved, this is just something that happened one time, this is not a repeat occurrence, we can actually provide an administrative waiver over the phone. You do not need to complete any paperwork for this. You can call us, we'll go over the information. If you meet the qualifications for an administrative tolerance waiver, we can apply it simply by a phone call, no paperwork necessary. Well, March of 2024, they expanded that tolerance waiver up to $2,000 or less now. So $2,000 or less, no fraud or fault involved. You can ask us to waive that. We are making our repayment plans a little more flexible. If you meet certain criterias, you can ask for as little as $10 a month. Again, we take these on a case-by-case basis. There is the potential here, if you meet that qualification, you would not need to complete the paperwork. So call the representative, have them walk through the requirements, see if you meet that. And if so, they can simply go in to the record and apply the $10 a month withholding on the overpayment versus what they were withholding before. Used to be on the Social Security side of things, that used to be if you received an overpayment notice and you did not respond to the notice that we sent you, we'd give you the ample appeal time, the 60 days. And then after that, if we didn't get a response, we held your entire check and applied it towards the overpayment. We've discontinued that. If you get the letter, you don't reply in the appropriate appeal time period, they will simply do a 10% rate of withholding to pay back the overpayment. So that should help some individuals there. In addition, used to be, we didn't need to fill out a waiver. There didn't used to be any paperwork if we could get the overpayment paid back in three years or less, okay, without a waiver. We've actually expanded that now. Now it's 60 months or 5 years. So if you have an overpayment, you're having a hard time making ends meet, you can go back in and let's see if we can recoup that and lower that payment amount for you. If we can get it back within the 5-year period, then we just simply need to ask you a couple questions and do it by phone. No need for paperwork there. So if you know someone falling into the overpayment scenarios, or you yourself, work with Social Security. We have, like I said, streamlined the overpayment repayment process. We made their payments more accessible by reducing the minimum payment withholdings, things of that nature. Before we get into the SSI updates that began in September 30th, are there any questions about the overpayments?
Kim, if we could just digress for a moment, though, because someone did ask a question about if a patient is hospitalized for an extended period of time, at what point do payments stop, or how does one get reinstated?
Okay, so normally if they're hospitalized, the standard rule is for 30 days or more. That's an institutional setting. Usually depends on the institution. So in a hospital setting, they usually will go, the SSI recipient will drop down to $30 per month. However, there is, and forgive me about this, but my brain is not quite working this Monday morning. There is a procedure that if an SSI individual is hospitalized, it's expected to be longer than 30 days, but less than 90 days. And they have bills to pay, meaning they kept their apartment when they were hospitalized. They still got to pay their rent, things of that nature. There is a form that the hospital can verify, yes, this individual will be released after 90, before the 90-day period. They do have bills to pay, things like that. We can actually continue their full SSI payment, whatever they were receiving before they were institutionalized. We can keep them going on that payment plan. So there is a provision there, and I'll get the policy and the information about that. I'm just not thinking of the terminology, but if it's a short stay in the hospital, expected to be less than that 90-day period, they don't necessarily need to reduce their SSI payment. I hope that helped.
Thank you. That's it.
Okay. And like I said, I'll get that to you guys as well, since I can't, it's a temporary institutionalization is what that is, but I'll still send you some information about that. So beginning September 30th, just a few weeks ago, we have updated the SSI program, trying to make the SSI program a little more streamlined, removing some barriers and allowing more individuals to have access to actual payments. Now, as you know, that is our needs-based program. So we are always looking at, is somebody else paying for something for you to help you, function and live in our world? Well, the first thing that we are removed beginning September 30th is we will no longer include food as in-kind support and maintenance in our calculation. So we're now no longer going to ask, are you receiving food from another source? Is someone buying you groceries? Things of that nature. In certain scenarios prior to September 30th, your benefit amount could be reduced if someone was providing that for you, that service for you. Of course, we've always excluded food stamps, but there were scenarios where people would buy somebody groceries and stuff, and we would have to reduce their payment due to that. We're going to take that out. So we will no longer ask questions about, food. Are you receiving food from other sources? Are you eating out? Are you buying food separately from your household? Things of that nature. So that is out. So that's good news. That's less questions we have to ask, less questions the individual has to answer. Another one is we are expanding the rental subsidy policy. There were certain states that allowed more expansion of rental subsidy. And then there were states that said, you are not paying your fair share, or someone else is providing you a service, for rent, living expenses. So we're going to reduce your payments. Okay. So what this looks at, rental subsidy in this scenario that's changed is when someone in the household is related to the landlord as a parent or child. We consider that still a business arrangement. And if their rent exceeds the lesser of the presumed maximum value or the current market value. So usually when a parent, let's say it's a parent-child scenario, the parent is renting to the child. And usually, because that's the parent-child scenario, you usually expect a favor, mom and dad aren't going to charge you as much as they would a standard person, right? A normal person off the street. So they cut you some slack. Well, it kind of used to be an all or nothing scenario. If you weren't paying your the current rate, we would just reduce your payment significantly. Okay. Now we look at one, is the rent greater than the presumed maximum value, which is 1/3 of the federal benefit rate, or is it greater than the current market value, rental value? So if the rent they're paying is greater than one of those, we don't even have to look at rental subsidy. They'll still get their benefit amount, okay? So we'll no longer reduce that. So we're going to compare it to the presumed maximum value or the current market rental value. If it's less than that, then we basically go with the one that is the least amount, the least difference, okay? So this means that some SSI recipients may get an increase. They won't be reduced as much for rental subsidy. It may mean that some individuals actually qualify now for SSI where before they didn't due to the rental subsidy. So it might allow access to more benefits. There's the policy information there if you want more information about it. I did include a couple examples. So the presumed maximum value, the PMV is what we use for 2024 is $334.33. So let's do a quick example. An SSI recipient is paying $280 a month, October of 2024. The landlord, who's the recipient's child, so we have that established parent-child relationship, verifies the monthly required rent and states that the current market value for this place is $410. So on the market, they would rent it for $410, but because this is their child, they're going to charge them $280. Well, we have to look. Current market rental value is $410. The presumed maximum value is $334. So the rent is under both of those. So we do have to look at rental subsidy now. So we're going to subtract $280 from the PMV right here, the $334, because that's the lesser of the two. So that means this person's rental subsidy amount, their SSI payment would be reduced by $54.33 versus before reducing it by the whole $334.33. Okay. So we're taking the difference. Another example is an individual receives SSI and pays their mom $350 in rent. That $350 is above the presumed maximum value, okay? No rental subsidy exists, even though the current market rental value is $500 per month. So we look at both of these. And if the rent is above one of those, there's no subsidy involved. And here's another one. An SSI claimant's paying rent for $200 a month to their father for a basement apartment. The rent is less than the PMV. Therefore, the rental subsidy must be developed. Current market rental value is $500. So what are we going to do? We're going to subtract the PMV and the actual rent they're paying. We're going to take the difference. So the one that's lesser, the least damaging amount, the individual will have rental subsidy, meaning their SSI payment will be reduced by $134.33 due to rental subsidy. Okay, so I know that may be a little bit confusing. Hopefully those examples, you can kind of refer back to them. And of course, always contact Social Security if you feel somebody's being incorrectly calculated for rental subsidy now that the new rules have been put into place. Lastly is something called public assistance. It used to be if an individual, let's say everybody in the household was getting some form of public assistance. So an SSI recipient, a TANF recipient, and maybe some other form of public assistance. We didn't have to develop sharing for that. However, if an SSI recipient was with, let's say, someone else receiving TANF, and then a third person does not receive any public assistance, that used to be a sharing situation where that SSI recipient we had to develop what's your rent, what's your electric, what's your water. Prior to this, what was your food expenditure, what's your gas bill, what's your trash, sewer. We had to develop for all of those bills in the household, divide by the number of people in that household, and then that SSI recipient had to prove that they were paying their fair share of those household expenses. So since September 30th, we have now expanded the public assistance definition. Now we consider it a public assistance household, where before it used to be an all public assistance household. And as long as just one other person in that household is getting a form of public assistance, including food stamps, we will not have to develop for sharing. So if the SSI recipient is living with 4 other people, they're receiving SSI and one other person's getting food stamps, we will not need to develop sharing. So that'll save us time, it saves the beneficiary time, and it allows them more access to payment and services. So those just went into effect recently. Okay, and these are just listings of what's considered public assistance. So here's a listing. We're already out of time, so I don't want to go through all of these, but just for reference, you'll have this there. This was another one for the public assistance household. I kind of gave you that example. As usual, please don't fall for scams. Don't provide information to somebody you do not know is the actual source requesting information from you. If Social Security is trying to reach you and you're not sure it's really us, please hang up. Call us directly. We'll let you know if we're trying to reach you. Plus, if Social Security is making a determination about your benefits or eligibility for benefits, we're going to send you a notice. Because any change on your record, we have to grant you appeal rights. So mail is our formal way to notify you. If you get a call and someone's threatening legal action or threatening to do something to you, if you don't provide information, probably a scam. Couple of them that stand out is if someone says we're going to suspend your Social Security number, do not respond, hang up the phone, delete the email, because we cannot, that function doesn't exist in the Social Security world. We cannot suspend a Social Security number. A very common one now that's coming up in the last couple of years is as soon as they announce the COLA, cost of living adjustment, which we just recently did, they're calling and they're saying, we're from Social Security. We just need to update your personal information, your address and your banking information so you can receive your increase in January. Social Security will not do that. We will not contact you individually to update your information with us for the cost of living. So be careful with that as well. Those are just 2 that recently have been coming out of the woodwork. Now you can file applications for retirement, spousal benefits, disability, Medicare, all online. If it's a child claim or survivor claim, that does need to be completed by phone or in office. These are our national numbers here. I did provide, I think, contacts to each office. Bear with me just a second. If you do visit an office, these are the new kiosks. You can actually use mobile check-in. You can scan with your phone. There's a QR code at the door and then when you come in. But if you wish to check in with a machine here, you are to do that, I just wanted to give you a visual of what you may encounter when you visit an office. Pennsylvania, these are the field offices that I work with. These is their standard general inquiry lines, which are open Monday through Friday, 9 a.m. to 4 p.m. If you need to fax something to an office, these are their fax numbers that will go directly to their office and to their repository system. And we did it. That was it. So we finally made it through. I really appreciate your attention today. Thank you so much for joining. Patty, thank you for inviting me.
Oh, sure. And Kim, there's still there's a couple questions. Do you have a
Yeah.
couple minutes?
Yeah.
If not, we totally understand. Okay, go ahead, Maria.
Okay, if you, someone asks if you charge no rent to your SSI adult child who lives with you and the child pays their share of household expenses, that won't cause a reduction in SSI? There's a question.
If they're an adult child living with you receiving SSI and they are paying their fair share, you can either complete a form or you can do it verbally over the phone with somebody, then they would retain the full SSI payment amount. Provided there's no other income, like if they're not working, things like that. If they're working, obviously wages count against them, things of that nature. But yes, they should get the full amount if they're paying their fair share of those household expenses.
Okay, and someone asks, does Social Security do marketing for Ticket to Work?
Do marketing for Ticket to Work? Like we discussed Ticket to Work, they are a resource provider for us that helps individuals access services so they can find employment. So I'm not sure of the question. We do have Ticket to Work information on our website. And then, I can give you more resources if you would like that, if you need that. Well, if there's anything else you definitely have my email address there on the presentation. Please feel free to email me. I will send out information. We talked about the deeming chart for SSI purposes. That's how parents' income can affect a child. What it's earned income and unearned incomes on that deeming chart. If you have trouble reading that, you need that for a particular person purpose, let me know. I can give you a little tutorial on that. Sometimes it's not the most user-friendly chart. Okay. And then any presentations you had mentioned, there might be interest in a presentation that you would like to see, the PowerPoint, let me know what those are. I'll be happy to send. And then we also talked about the temporary institutionalization, getting the policies out for that, what that means, what's the definition behind all that. Did I get them all?
I think you did, Kim. Thank you so much. I feel like we could spend days on Social Security, and it just takes time. And we know from talking to families that sometimes you just have to hear it a couple of times before it clicks. So again, we really appreciate you taking the time out of your busy schedule to spend all this time with us. And for everyone in attendance, thank you for sticking with us. We've had people not just locally here in Allegheny County, but all across the state on this webinar this morning. So thank you so much, Kim. And again, thank you everyone for attending. And thanks, Maria, for answering all those questions. I couldn't do this without my colleague, Maria Smith. So thank you too, Maria. I appreciate it.
Thanks so much, Kim. It was great. Terrific. Terrific. Very good.
Okay.
Thank you.
Have a great day, everyone. Thank you.
Take care. Bye.
Bye-bye.